The honourable member for Cypress Hills Grasslands.
Thank you, Madam Speaker. It's good to be here today to speak to Bill C-14. One of the principles that I think we have in this House is that legislation is best built on a very solid foundation, and I believe today that this bill does not have that. The Supreme Court had ruled earlier that on the Rodriguez case was very clear. But a year ago, just over a year ago, as with so many other decisions and so many other directions, the Supreme Court had reversed itself, and if they had really good underlying reasons for doing that, I think it would have been fine. But the justification for it was very interesting, and I think it was a mistaken perception that they set forward of what they see as changing, and they called it a changing matrix of social and legal facts that had brought them to the conclusion that they reached. And I guess and there's others I know who are concerned that that makes our laws, including the interpretation of charter rights, dependent upon the opinions of a very small group of people. And we're going to talk a little bit more about that idea of the matrix of social and legal facts in a few minutes. The reality that, from my perspective, I think, Madam Speaker, is that this was not an improvement. Bill C-14, I've heard my colleagues in the House, on both sides of the House here, share many of their concerns, some supporting it, some opposing it, but there are a number of things there that I think that the bill is missing that we need to have further discussion about. I heard a few comments earlier about the timeline and how pressured it is and how we need to get this done, and it's basically prohibiting us from being able to take the time that we may need to discuss these things a little bit further and with a little bit more depth. One of the things that I think is lacking is a clear definition of what irremediable means, because it talks about that being the requirement for someone to qualify for this. I'm concerned about the expansion of this process to nurse practitioners, so it doesn't just include physicians. I've talked to people who said, why are medical personnel involved with this at all? Isn't there some other place that we can do this so that people don't have to be concerned that when they go into the hospital, they go to get medical care, that they're going to find that they're not receiving a positive side of medical care, but a very negative side of that. There is a criminal exemption for those who perform euthanasia, but it's interesting that there's no protection for those who do not want to participate. I guess there's a number of people, I've heard that often, that are very concerned about what is called conscience rights, but it's just interesting that in the legislation the government would have put that protection for people who want to participate, but did not put any protection, did not even try to put protection in for those who do not want to participate. There's a lack of clarity around psychological conditions and how that may come into play with this issue. One of the things that really concerns a lot of people is a lack of a vulnerability assessment, taking the time to find out if someone is being pressured, or if there's some vulnerability that's bringing them to the point where they have made a decision that may be wrong for them. There are people who have called for prior judicial review. There's no mention of that in the legislation as well. Very great lack of clarity on data collection as well, and this has been an issue in a number of areas as well. That are we going to see good data collection? Is someone going to keep a good set of records on what's going on with this process? And a concern, and we've heard this often, we just heard the member opposite from the government talk about this, but there is no clear commitment to palliative care. And this was a commitment that was made by the Liberals when they were campaigning. They seemed to feel that it was within their jurisdiction then to promise $3 billion towards palliative care. But in the House here, we hear them talking about how other jurisdictions have responsibility for this, and it sounds like they're trying to avoid their responsibilities on this issue. But, Mr. Speaker, I'd like to go back to the Supreme Court decision. It turned back the former position, it reversed it, and it left us with some pretty open field when it comes to the area of assisted suicide or assisted dying. Basically, the only things that they, in their ruling, said need to be accommodated in the Carter decision was that the person needs to be able to consent, and that the person has a grievous and irremediable medical condition that causes enduring suffering that's intolerable to the individual. I think, Mr. Speaker, if we take a look at that, it leaves that whole area very, very open. And as I said earlier, good legislation should have a good foundation. I don't believe that this does. And the reason I believe that it does not is because of the Supreme Court decision. The foundation is a Carter decision. It hardly qualifies as a stable base on which to create good legislation. I'd like to take a few minutes, and I don't suppose we'll get done today, but we will come back at another stage on this bill and just talk a little bit about the Supreme Court's recent decision in Carter versus Canada It obviously was a very controversial decision, touches on a sensitive issue for many Canadians because there are very deeply held beliefs on both sides of this issue. The Supreme Court acknowledged that, as they said, the prohibition on assisted suicide is in general a valid exercise of federal criminal law. It also decided that the law went too far, and it didn't apply in cases where a competent adult with that grievous medical condition can consent to the termination of their life. I believe this decision is disturbing for a number of reasons. The first would be, Mr. Speaker, that the Court ignored parliamentary consensus. In its decision, it claimed that the reversal from its earlier position in Rodriguez versus BC was necessary because of a different matrix of legislative and social facts. Yet the purported differing matrix ignores the clear and unchanged parliamentary consensus opposing assisted suicide. Between 1991 and 2012, 9 private members' bills were introduced in the House of Commons seeking to amend the criminal code to decriminalize assisted suicide or euthanasia. 6 were voted on. All of them failed to pass. When considering the matrix of legislative facts, the Court gave weight to legislative developments in Belgium, Switzerland, Oregon, Washington, and the Netherlands, but they completely ignored the legislative record of Canada's Parliament. Secondly, Mr. Speaker, the Court found no societal consensus in Canada on this issue. So in her decision at the trial level of Carter versus Canada in the Supreme Court of BC, Justice Smith wrote, "As to physician-assisted death, weighing all of the evidence, I do not find there is a clear societal consensus either way." Clearly, whatever the change in the matrix of legal and social facts entailed, it did not include a clear consensus from the people of Canada. And this lack of consensus remains unchanged in the 22 years since the Rodriguez case, in which the Court stated no consensus can be found in favor of decriminalization of assisted suicide. To the extent there is a consensus, the judges wrote, it is that human life must be respected. Thirdly, Mr. Speaker, the Court found no consensus amongst Western countries. While insisting that, again, this matrix of legislative and social facts has changed since the last Supreme Court ruling on the issue, they acknowledge that physician-assisted dying remains a criminal offence in most Western countries. Regardless, they chose to align themselves with the minority of jurisdictions that allow that. Now, Mr. Speaker, I believe the Court misinterpreted Parliament's objective in prohibiting assisted suicide. In their ruling, they put significant weight on the parliamentary objective of 2 sections, Section 241B and 14 of the Criminal Code, which prohibit assisted suicide. And the Court asserted that these sections were put in place only to fulfill the state interest in protecting the vulnerable. But earlier, in the earlier court case with Rodriguez, the Court had said the objective of this section was not simply protecting the vulnerable, but also preserving life. And so they had written, in this case, it's not disputed that in general this section is valid and desirable legislation which fulfills the government's objectives of preserving life and protecting the vulnerable. The position was reaffirmed several times. So, Mr. Speaker, by insisting that in Carter that the purpose of 241 was only to protect the vulnerable, the Supreme Court was able to conclude that this prohibition puts people outside this class and that there are people who do not need to be protected by it. So they said that the Court's conclusion was that the current law was overbroad and grossly disproportionate to its objectives, and that allowed them then, Mr. Speaker, to say that Parliament just needs to establish safeguards to ensure that those who truly want to live and who truly want to be euthanized will be able to do that. And I think, Mr. Speaker, that interpretation tramples on the intention of Parliament. It tramples on the intention of Parliament to preserve life. And had they considered the full purpose of these sections of the Criminal Code rather than just that one objective of protecting the vulnerable, I think the outcome would have been very different, Mr. Speaker. So just one final point, I think my time is running out, that the Court really leaves the definition of irremediable open to patient interpretation. The Court decided that irremediable does not require the patient to undertake treatments that are not acceptable to them. In other words, although treatment may be available, the condition still qualifies as irremediable if the treatment is not acceptable to the patient. So, Mr. Speaker, I think just based on those things, and I see my time is running out, but I wanted to express my concerns. I think we'll come back to some of the things that the Supreme Court touched on as well in terms of the right to die being conflated with the right to life and some of the other issues. But thank you for the opportunity to speak to this issue today.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. I appreciate the comments from the member, but I wanted to highlight that the Supreme Court of Canada did in fact unanimously decided that Canadians suffering intolerably have the right to request assistance to end their suffering. Mr. Speaker, we respect that decision of the Supreme Court of Canada, as we would think that all members of this House would do so. The issue before us is not if Canada should have medical assistance in dying, but rather how we make it available. It's important, Mr. Speaker, given the sensitivity of the very issue that we're debating today, that we recognize that we have till June 6th in order to ultimately deal with the issue. If we do not deal with the issue, which would be most inappropriate as parliamentarians representing Canadians from every, obviously, coast to coast to coast, that there is that obligation for us to meet that void that has been put in place by the Supreme Court of Canada. Would the member not at least acknowledge that, that we have to pass some legislation? And does the member see any possible amendments that he himself would like to see that would make it easier for him to support the legislation?
Honourable member for Cypress Hills Grasslands.
I think, Mr. Speaker, my point was exactly that it is the court that has brought us to this point. And it is that the timeline is the court's timeline. I think that actually, as one of my colleagues pointed out a little bit earlier, that deadline prohibits us from being able to deal as fully with these issues as we probably should. We haven't had any discussion about the implications of what the Supreme Court decision is. We've never sat down and had those discussions that we need to have about that. The government's come forward under pressure with legislation that many people feel is inadequate. I guess one of the areas that I find very troubling is the lack of conscience protection. I mentioned that a little bit earlier. There are many people in the disabled community who are very concerned about the fact that there's no vulnerability protection, that they don't want to see a development of a peer pressure, if you want to call that, in our society where people feel somehow obligated then that they need to participate in this activity. So there's a number of issues around here. The timeline that we're on is not helping us in discussing and resolving those issues amongst Canadians.
Questions and comments? The honourable member for Vancouver Kingsway.
Thank you, Mr. Speaker. Well, I'd like to thank my honourable colleague for his remarks. And following up on the question of my honourable colleague on the government side, I share his concern that we seem to be moved towards filling a legislative gap because of the Supreme Court's decision. That's very true. But on the other hand, it strikes me as just the realistic situation that if we do not have legislation in place by June, the June date that the Supreme Court gave, then we would be in the untenable position in this country of having a legislative vacuum where there would be absolutely no provisions concerning assisted death at all, because the Supreme Court has found that the provisions of the Criminal Code that govern this matter are unconstitutional and only suspended the application of that judgment until June. So I'm just wondering if my honourable colleague has any thoughts about how we could bring in appropriate legislation and also avoid the untenable situation of having a legislative lacuna in Canada.
Honourable member for Cypress Hills Grasslands.
Well, I guess, Mr. Speaker, one of the things is that we are here. We're having the debate. We're having the discussion, trying to have that discussion within the timeline that was been established, trying to do a good job of setting up the guidelines and the safeguards that need to be in place on this issue. And, the reality is that the acceptance of assisted suicide and euthanasia is not universal across this country. It was not something that was decided by the elected members of this House and those who are here to represent the people. It was decided by the Supreme Court of Canada. They made their decision that we have a charter right to this in Canada, and so we need to move forward with this legislation. But I don't think that the Parliament of Canada I do think that the Parliament of Canada needs to take some time and do this carefully and make sure that we're doing it correctly for people. There's a number of other things I had to say. One of them would have been about the slippery slope that countries find themselves on when they move into this area, and we need to have a discussion about that as well, and I don't hear us talking about that in the terms that we should be doing that.
Reprise de débat.
Resuming debate, the honourable member